Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to get to talk about a case that comes from Illinois, but this is a national perspective that we need to take on this case, not because of what's at stake, but who just jumped into the fight with it. We're talking about the matter of Barnett v. Raoul. It is one of the many challenges going on in the Seventh Circuit to the Protect Illinois Communities Act, or Illinois' assault weapon ban. We already talked about how the United States Department of Justice actually filed an amicus brief in support of the petitioners. Well, now they're taking it one step further. So today, let's spend a few minutes and let's talk about when the DOJ wants a piece of the action. Okay, America, we're talking about assault weapon bans. We're talking about the Protect Illinois Communities Act. We're talking about bad legislation, and we're talking about a big fight in court. That's right, we're talking about Barnett v. Raoul. Now, there are multiple cases that are consolidated on it, and as you know, this is set for oral argument before a 3-judge panel on September 22nd. Now, we already did this video right here where it was like, oh my God, check it out. The United States Department of Justice actually filed an amicus brief in support of the petitioners, translation actually in support of lawful and responsible gun-owning Illinois residents. Well, now they have taken it one step further because they have asked for and filed with the court right here an unopposed motion to actually get some oral argument time. That's right. The United States Department of Justice is asking for a few minutes of oral argument to argue before the Seventh Circuit 3-judge panel, again on behalf of lawful and responsible gun-owning Illinois residents. Now, there are certain rules of appellate procedure that I'm not going to bore you with because they would candidly bore the hell out of me as well, but the pertinent part of the unopposed motion filed with the Seventh Circuit reads, this appeal concerns whether Illinois' Protect Illinois Communities Act, which prohibits so-called assault weapons, can withstand scrutiny under the Second Amendment, which protects Americans' right to keep and bear arms. Because of the federal government's interest in protecting the Second Amendment rights of all Americans, citing to the President's executive order, the United States filed a brief as amicus curiae in supporting plaintiffs' appellees. The United States believes that its participation in oral argument will be helpful to the court. Okay, and I want you to just stop and think here for a second, okay? I know that you're not all thrilled with everything that's come out of the Department of Justice. I know you're not all thrilled with everything Pam Bondi has done or has not done. I get that. But did you ever think in a million years that you would now be in a moment when the United States Department of Justice has not only filed an amicus brief in the Seventh Circuit on behalf of gun owners, but is actually asking for oral argument time? In addition to all of that, check out who the United States Department of Justice intends on sending in for oral argument. If the court grants this motion, the Assistant Attorney General for the Civil Rights Division of the Department of Justice, Harmeet K. Dillon, will present oral argument on behalf of the United States. How much time are they asking for? Not much. The motion also requests, this court's calendar currently indicates that the court has allotted 45 minutes of argument time to defendants' appellants and 45 minutes to plaintiffs' appellees. Counsel for plaintiffs' appellees consent to this motion and have agreed to cede 5 minutes of their oral argument time to the United States if this motion is granted. As a result, the United States' participation in oral argument will not affect the overall time allotted for this case. So listen, they are only asking for 5 minutes, but that is 5 more minutes than they've ever given lawful and responsible gun owners any time before. So again, I'm not sitting here telling you that the DOJ is suddenly the greatest thing since sliced bread. I get it. It's the DOJ. Have we seen significant improvements? Yeah, I think you have to admit we have. Have we seen some actually pretty monumental occasions? Yeah, we have. And this is another one. Okay, the case once again is Barnett v. Raoul. It's set for oral argument before a 3-judge panel on September 22nd. We're going to link it all up down below. We'll link up the unopposed motion down below so you can geek out on that for yourself as well. Listen, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington Gun Law by now. If you don't, that's okay. That information down there in the description box. If you got an idea for a video we should be doing around here, cool. Click on that link right there and tell us all about it. If you want to subscribe to the monthly newsletter, the ability to do that is down there in the description box. And then finally, And most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe. Why in the year 2024 should anybody even think about having self-defense protection? Because, 25 years ago, we would have never had this conversation. So what's different today?
Bill, we really saw a need a number of years ago when the volatility and divisiveness of our country started to change drastically. And we, by the way, are gun people protecting gun people. We come from a significant gun background.
Right to bear, that's right, legal protection for self-protection. Listen, good lawyers aren't cheap, cheap lawyers aren't good. You're not truly prepared unless you have right to bear back you. You will always get an attorney-answered hotline, so you will always have a confidential phone call. There are no cap limits for either civil or criminal defense. This covers all forms of self-defense. So from a fist to a firearm, from a fat lip to a dead body, you are covered, and you will have some of the nation's most passionate 2A attorneys in your corner fighting for you. And right now, if you visit my friends at protectwithbear.com and you use the promo code WGL, you will receive 10% off. Listen, you need to protect yourself so that you can protect them. Visit my good friends at protectwithbear.com.